Okay, I'll go ahead and make an introduction as a few more people will probably be joining us. We are at the scheduled start time and I don't want to keep anyone waiting. We will go for about an hour. I will take questions and answers through the chat window. Feel free to type those in as you have them, but I will usually wait until the end of the presentation for a question and answer segment. The presentation today is on accommodating New York employees with disabilities, or how to be a reasonable employer. My name again is Scott Horton. I am the founder and attorney with Horton Law PLLC in Orchard Park, New York. Horton Law's been in operation for about 2 years. I've been practicing for close to 15 years now as a management side labor and employment attorney. And over those 15 years, I've come to realize that while I went to law school because I didn't want to be a doctor, the practice of employment law entails quite a bit of medical issues because of the number of laws out there at the state and federal level, and now increasingly even local levels, that pertain to medical issues and leaves and accommodating employees in one way or the other, either because of their own medical conditions or those of their family members. So here is an overview of what we're going to discuss today. I just want to also give the disclaimer that because I am presenting this to a group of people, some of which are not my clients, others of which have retained me in particular matters, there is no legal advice per se technically being given in today's presentation because your specific situations could dictate a different outcome or best practice or best approach. But most of this information is of general interest to employers. We are focusing on New York employers and employees for purposes of discussing some of the relevant laws, but by and large, because the Americans with Disabilities Act applies throughout the United States, if you do have employees in other states, much of what we're going to be talking about would be relevant there as well, but there might be state or local laws at play elsewhere that is beyond today's presentation. So just briefly, we're going to talk about the key terms: reasonable accommodation, undue hardship, the interactive process. We are also going to talk about a few special issues at the end, including a relatively recent change to the New York City human rights law for those of you who not only are in New York, but have employees actually working within the confines of New York City. But for the most of you who don't have employees in New York City, that is going to be at the end and only a small portion of the total presentation. And nonetheless, that topic might still be of interest to you because it is a recent development and something that perhaps could be on the table at the statewide level in the future. I just want to real quick throw up a poll. I'll just do a couple of these throughout the presentation. So the first one is going to ask whether you are involved in handling disability accommodation requests for your organization. A few options should come up. If you can click the one that most applies. We have some answers coming in. So far, everyone here says yes, which obviously makes sense since you are in the webinar on accommodations, but we do have someone now saying no, or multiple people saying no. So maybe you might get involved with that, or you just need to know more about it as a general matter. But the overwhelming majority of you, it looks like, are occasionally involved. And what that means to you could be different whether your organization handles many accommodation requests or a few. There are certainly large organizations that get accommodation requests on a daily or more frequent basis, and many others that are smaller and only have occasional requests to address. So thanks for that feedback. And with that, we're going to get right into the substantive material. So just briefly, there's going to be a lot of words on these slides, and I will mention that I will give you a link to download these slides in PDF format at the end of the presentation. You will also receive a link to those in a follow-up email, which also serves as confirmation of your attendance for those of you who might need that for credentialing purposes. But I'm not going to read all of the words on the slide. Some of it's just there for your background. And most of it are concepts that you have some familiarity with, but we're going to go into some more detail on some of the nuances and complexities that I hear clients and employers dealing with on a day-to-day basis. So broadly speaking, we're talking about the Americans with Disabilities Act and the New York Human Rights Law. And if you have employees in New York City, the New York City Human Rights Law. The Americans with Disabilities Act applies to public and private employers throughout the United States that have 15 or more employees. So if you have 15 employees in your organization, the ADA applies. In New York, the Human Rights Law protects employees with disabilities and entitles them to reasonable accommodations for any workplaces with 4 or more employees. So obviously there's a lower employee threshold for the human rights law to apply, but if you are in New York and have 4 or more employees, then it does. And then if you also have 15 or more employees, you are subject to both sets of laws and regulations. Again, if you're in New York City human rights law applies as well for employers with 4 or more employees. For most purposes we're going to be discussing today, the analysis under the New York City human rights law would be similar to the analysis under the ADA or the New York State human rights law, but we will talk about a recent change, as I mentioned at the end. Just briefly, covered employees are individuals with disabilities. Under the ADA, the definition involves impairment that substantially limits one or more major life activities, having a record of such impairment, or being regarded as having such an impairment. So the substantial limitation on major life activities prong excludes relatively minor, I suppose, disabilities. Although as a result of amendments several years ago, the ADA now has more extensive coverage than it used to by reducing the bar as to what substantially limits mean, for example, and expanding the scope of major life activities. The reason I have or is regarded as having such an impairment in blue up here is just for the purpose of this presentation on accommodating employees with disabilities. There's no obligation under the ADA to accommodate employees who were only regarded as having an impairment if they're not actually an individual with a disability under the ADA. The definition for the human rights law is up here. The reason I've highlighted just impairment is the rest of these words around impairment under the New York law ultimately collapse into a very low bar as to what qualifies as a disability. In other words, pretty much any observable anatomical, physiological, genetic, or neurological, anything you want, type of impairment would qualify someone as having a disability in New York. There's actually no specific carve out for people who are only regarded as being impaired, but I think for most practical purposes, it's fair to assume that, like the ADA, someone who doesn't actually have an impairment or a record of an impairment, but is only falsely perceived to have an impairment, probably is not entitled to accommodations. So again, it's a lot of the legal mumbo jumbo for your record here. Again, with reference to the ADA are the major life activities set forth in the federal regulations. It does note that these are examples, but not an exhaustive list. But as you can see, pretty expansive and including things like seeing, hearing, eating, walking, standing, So this is broader than what used to be before amendments several years ago, major life activities under the ADA. I'm not going to spend too much time on that because, again, with all of you in New York at least, the bar for impairment is pretty low. At one point in time, someone for the Division of Human Rights in New York basically suggested that a hangnail would qualify as a disability under New York law. I don't know that it's quite that minimum of a standard, or that there'd be a reasonable accommodation to be had for someone with a hangnail, but just in case, I use that as an example of at least approximately how low the barrier is. The more important aspect than usually deciding whether someone has a disability per se is determining what the essential functions of the job are in determining whether the employee needs an accommodation. So the laws, both the ADA and the human rights law, effectively say that you have to provide reasonable accommodations to enable people to perform the essential functions of the job. If it's not an essential function of the job, then you may not be able to require them to do it in the first place as a condition of continuing in the position. So the first couple bullets here are more directly out of ADA regulations, and then the third specifically comes from the human rights law, but they all more or less get to the same point. So it's the fundamental job duties. It's sort of the essence of what the job entails. And in New York, the regulations suggest, would the job fundamentally change if this function was not performed by the person in it? The reason I have this picture of a man holding boxes here is pretty standard case of employers putting in their job application or their job announcements, for example, their want ads, that you need to be able to lift a certain amount of weight. Hopefully when companies are putting that in, it's because there's a legitimate requirement in the position to be able to lift that amount of weight. But historically, there have been less reputable companies that have put that in for more subtle discriminatory purposes, potentially including weeding out people who may have some physical impairments. So again, if you're stocking shelves in a warehouse, then it's probably an essential function of your job to be able to lift relatively heavy boxes. If your job usually just entails typing or sitting at a desk and only occasionally would require you to lift a box, for example, if a delivery person drops it off at your desk, then it's probably not an essential function. Again, this is really just a term we're going to come back to as we're going through some of the accommodation analysis. Here are some of the factors that get determined and whether something is an essential function. I'm not going to read all of these, but you kind of get the gist. But you can see this is under the New York human rights law regulations. The next slide will be under the ADA. They're similar, but not exact, but in neither case are they necessarily exhaustive. They're just sort of guidelines of what types of factors should be considered in determining whether something is an essential function in the first place. So again, some of the items you would look at is whether most people in that job would perform the task, whether you have written job descriptions identifying it as an essential function of the job, the amount of time that someone in that position normally spends doing the function, for example. I did want to put up one more poll here because I was curious on the job descriptions. If you know, does your organization have written job descriptions that identify the essential functions of each position? Because this really is one of the strongest legal justifications for having the written job descriptions in the first place is being able to determine what the essential functions are. So you see some of the items that I let you choose from are based on how frequently and recently you've updated these job descriptions. So good to see that most of you have written job descriptions and review them regularly. Many companies draft them when the job is created, for example, and then don't periodically review them, so that over time, what's in the job description is not necessarily what is actually being performed. You can imagine situations where companies have been around a while and their job descriptions refer to technology that's completely outdated. Secretaries, for example, it might say they need to be able to type on electric typewriters, where hardly any workplaces are using those on a regular basis these days. Among various other things. It could be more simply you need certification to operate a certain type of equipment, and that equipment is no longer what's being used. So if you do get into an analysis of what do we have to accommodate and what is something that we don't have to, or we can't require the employee to do to remain in their position, then the job descriptions could become relevant. But of course, they're not dispositive in any situation. There would still be other factors to be considered. Okay, there's a lot of words. Again, I'm just giving you some of the legalese on this for your record. Reasonable accommodation, this is under the ADA regulations, modifications or adjustments to either an application process or to the work environment. We will talk briefly at the end about accommodating applicants. Modifications or adjustments that enable the employee with a disability to enjoy equal benefits and privileges of employment. The ADA regulations state that reasonable accommodation may include, but is not limited to, making existing facilities used by employees readily accessible to and usable by individuals with disabilities, and job restructuring, part-time modified work schedule, reassignment to a vacant position, etc. The human rights law defines reasonable accommodation this way: action taken which permit an employee, prospective employee, or member with a disability or pregnancy-related condition to perform in a reasonable manner the activities involved in the job or occupation sought or held, and include, and then list some examples. Just note that pregnancy-related condition is thrown in here in the New York Human Rights Law. It's also a component of similar language in the New York City Human Rights Law. It's not specifically addressed in the ADA, but to the extent that a pregnancy-related condition has something to do with the mother's health or physical condition, disability would probably encompass it anyway. So there's sort of a scope of protections under federal laws for pregnancy-related conditions, even though it's not specifically stated in the ADA. But for our purposes today, we're not going to have any reason to really separate a pregnancy-related condition from a disability, but there is the sensitivity to not specifically wanting to refer to all pregnancy-related conditions as disabilities per se, because of course many people think very positively of pregnancy-related conditions, even if they would prefer not to have disabilities. So again, more examples of accommodation just from the human rights law regulations. Here, the human rights law does note that reasonable accommodation does not include, among other things, providing for personal care needs, and providing non-work related aids such as personal hearing aids or wheelchairs, which are the employee's own responsibility. So, for example, an employee who needs to take a certain type of medication for their health, they might need that to be able to perform their job along with, living their life generally, but it's not going to become, in any but the most unlikely and unusual circumstances, the employer's obligation to pay for that medication. Again, under these laws, obviously, if you have insurance plans in place, they might dictate what you're paying for, but that's not an accommodation, even though, like I said, it might very well be necessary that they have that medication to be able to perform their job. The human rights law has some reasonableness factors. All of this really is going to play in when determining whether an accommodation is available, viable, and required. Technically speaking, again, there's going to be the issue of whether the accommodation is reasonable in the first place, and then the second analysis as to whether, albeit a reasonable accommodation, nonetheless creates too much of an undue hardship on the employer to require them to make the accommodation. The reasonableness factors go into basically whether the accommodation would actually work and enable the person to perform the essential functions of the job. The convenience of the accommodation, including its comparative convenience compared to other possible accommodations, and the hardships, costs, or problems it will cause the employer. So basically, by definition, whether an accommodation is reasonable includes an analysis as to whether the accommodation provides an undue hardship. So it's kind of academic to debate whether the accommodation is reasonable and nonetheless causes an undue hardship. The overall idea is, does the accommodation cause an undue hardship to the employer? But, for example, whether it causes an undue hardship or not, an accommodation wouldn't necessarily be reasonable if it didn't, in fact, allow the employee to perform the job. So to get more practical than all those long phrases and terms ripped out of the laws and regulations, tangible types of accommodations include physical equipment in the workplace, ramps or special desks or chairs, just other equipment that could be used to enable someone to perform a job that they otherwise wouldn't be able to. Job restructuring, leave, modified or part-time schedules, they kind of lump all of those in a sense, because a part-time schedule could sort of be leave if it means you're going to work a couple days a week instead of full-time. There's also a modified schedule. On the other hand, a modified schedule could include a scenario where the employee is still going to work the full number of hours, say 40 hours in a week, but be allowed to do it in 4 10-hour days versus 5 8-hour days because they need to travel one day of the week to receive medical treatment. Job restructuring could encompass some of those things, or it could entail actually changing the way the job is performed. It could mean moving someone to a different part of the facility. But again, it wouldn't always mean that you would have to do that. It would depend on what's an undue hardship. Modified workplace, that could be something equipment-based, installing ramps or changing the physical layout of an employee's workspace, but it could also be change in work rules, for example, prohibiting employees from wearing perfumes or other scented products because it aggravates employees' allergies or other triggers to their mental or physical well-being. And then reassignment, this recognizes there might be accommodation obligations to try to reassign someone who can't perform the essential functions of one job to another position. This would require, in the first place, that another position be vacant and that the employee needing accommodation is qualified for that job. So these laws clearly state that employers don't have to create new positions for employees with disabilities as accommodations. Nonetheless, as a practical matter, there are many employers who do in fact end up creating new positions to accommodate employees for various reasons. But again, that's typically not a legal requirement. And I just add other to this list because there's no limitation on the things that could qualify as accommodations. And if there is something else that doesn't fit into one of these other 6 categories listed above, that doesn't mean that it would not qualify as an accommodation if it is reasonable and would enable someone to perform the essential functions of their job. So here's where it gets really practical and tangible for most of you and me. The undue hardship analysis is what I am probably most often involved with discussing with employers. The employee gets something from their doctor or comes in and asks for something on their own that they want to have happen in the workplace. And sometimes it seems reasonable, sometimes it doesn't. But by and large, the issue becomes, is this something that we have to allow? And therefore the question ultimately becomes, does it impose an undue hardship? A little harder to see, but right under undue hardship, the definition under both the ADA and the human rights law is specifically significant difficulty or expense. There are a number of factors listed in the laws, but again, they're not necessarily the only factors that can be considered in determining whether something is an undue hardship. For the most part, most often, undue hardship pertains to cost. How expensive is the accommodation going to be? But there are also many circumstances where cost is not necessarily the most significant burden on the company, and the problem is really the impact on the overall workplace or the realities of having to deal with other employees who may or may not receive the same accommodation for various reasons, and that type of thing. But these factors, you'll see, for the most part, kind of imply that the larger an employer is, the more employees they have, the more people within the same general facility that could pick up the slack for an employee, for example, in some cases, are going to be more likely to have to allow a particular accommodation than really small workplaces. You know, not to say that a small company couldn't have more money available than a larger company, but you know, the gist of these factors goes that way. Bigger companies with more money and more employees will have a greater obligation to accommodate on average than smaller companies, perhaps startups, or if you want, mom and pop businesses that don't have as extensive of bank accounts and ranks of employees to fill in, which also means they have fewer positions to transfer employees between, which might also mean that they can't make as many physical modifications to the workplace, etc. One of the big areas for accommodation analysis is when, whether, and to what extent leave is a reasonable accommodation, and when does leave as an accommodation become an undue hardship. As we've already kind of looked at, both the ADA and human rights law regulations recognize that modified work schedules might be a reasonable accommodation in some cases. Also, both the EEOC and the New York State Division of Human Rights take the position that some period of time off might qualify as a reasonable accommodation. Like other accommodations, you must weigh the factors to determine whether leave poses an undue hardship to the employer. And it is very important to recognize and remember that satisfying the FMLA, where that applies, paid sick leave laws, like in New York City now, for example, where they apply, and other legal requirements, does not preclude the possibility that additional leave would be considered reasonable. So the clearest case is an individual who has been out of work for 12 weeks under the FMLA is not then able to immediately return to work. Obviously, the FMLA gives qualifying employees 12 weeks of leave, after which they have a right to reinstatement. After that 12 weeks, they might nonetheless be entitled to additional leave as an accommodation under the ADA or the human rights laws. There are still many employers who don't understand that and believe that once the 12 weeks is up, then they can send out a termination letter saying, thanks, maybe you can reapply, but for now you're off the payroll. Those cases are historically popular with the EEOC and New York State Division of Human Rights, in the sense that you are going to draw their ire if they see that happen in a set of facts that is brought before them, and they are going to pay attention to that case, and they are going to pursue it more aggressively than they might others. At least that is my experience with that issue. So there needs to be some consideration, for example, after the 12 weeks as to how much longer the person needs to be out, and then whether that is an undue hardship. Related issue, while I'm on that particular point, is the concept of maximum leave policies. The EEOC historically has opposed employer policies that set a specific maximum leave period. Commonly, these will say, employee may be eligible for an additional leave of up to 6 months or 12 months. Sometimes it's 2 years. I've seen some that are 3 months or less. The reality is that the EEOC and Division of Human Rights don't like those absolutes, because they look back at all of the laws and regulations and say that basically you have to consider multiple factors in deciding what's reasonable and what's an undue hardship, and bright lines don't consider multiple factors. The courts sometimes actually uphold these types of policies, so I'm not here to tell you that you can't have them, but they will be scrutinized by the state and federal discrimination agencies. What is probably the better practice and safer approach, therefore, is to have sort of a maximum guideline with the possibility of extension of the leave for some reasonable additional time period. So, for example, a policy that allows an employee to be on leave for up to 6 months, probably better if it's 12 months, but different situations might justify shorter periods. So you can be out for up to 6 or 12 months, and then if you need additional short periods of leave, then provide information and we'll consider it. I wouldn't word the policy that way, but that's basically the gist of it. Then at, or preferably a little before the end of the guideline period, the company would engage with the employee to get the information as to when and whether the employee will be able to return to work and perform the essential functions of the job, again, with or without some other form of reasonable accommodation. And if the employee is going to be able to return next week in full health, then it would be unwise to rely on the 6 or 12 months, whatever it is, period, to suddenly in their employment. But if they're still going to be out for an indefinite period of time or a long period of time, that's when you would then make the undue hardship analysis and determine whether you would have to then say, I'm sorry, we need to fill the position or whatever, otherwise move on, but you're happy to apply in the future if you're able to return to work. Again, remember, you can type in questions at any time if you'd like. I will answer them more likely at the end, but I don't want you to forget if you have good questions. We are now going to go a little bit more into the process with all of that kind of being background as to how to handle these situations and when employees and employers have obligations in the sense of the accommodation process. So I've summarized the process into 4 steps: the employee request, the interactive process, the evaluation, and the resolution. The employee request is some indication of the need for adjustments related to the employee's own medical condition. Remember, under these laws and making reasonable accommodations, we are talking about the employee's own medical condition, not a family member's medical condition, because these laws, unlike the FMLA or the New York Paid Family Leave Law, are only protections for the employee with a disability themselves. I should say on the employee request that the reason I called it an indication of need is because it's not absolutely necessary in every case that the employee actually verbalize a request. First of all, it's clear that if a family member contacts the company and provides enough information about the employee's medical condition and need for some accommodation, then you couldn't get by saying, well, the employee didn't ask for it, him or herself. Likewise, if the need for accommodation is abundantly clear, for example, an employee in a wheelchair who can't get upstairs, they really aren't required to further say, by the way, I can't get up the stairs in my wheelchair. And there are other situations where the employer has sufficient notice of the need for some adjustment related to medical condition. On the other hand, there are situations where the employee might ask for a change in the workplace, but not make it clear that it's related to a medical condition. And if the employer doesn't have other independent knowledge of a medical condition, that wouldn't necessarily trigger any obligation to engage in an interactive process for accommodation under the disability discrimination laws. For example, employee says that they need another monitor or they want a larger monitor for their computer at work. That in of itself, not obviously a disability accommodation request, because unless the employer knows that there's some, a vision related condition or something else that is causing the request, because it's plausible that somebody might just happen to prefer a larger monitor but not actually need one for a medical reason. But of course, if the company had an understanding that the person was visually impaired and they asked for a larger monitor, then it should at least be considered a request for an accommodation in this process. Pursue. So the interactive process is a phrase that actually comes out of the regulations from the ADA. It's the EEOC's guidance on accommodating individuals with disabilities. The reason I wrote here it's an informal exchange with the employee is because that's what the regulations under the ADA say. That being said, I wouldn't consider this informal in the sense of a casual conversation in the hallway. It's relatively formal as far as employee relations matters go. I think the reason it says informal here is more that doesn't have to have a lot of documentation back and forth. It certainly doesn't involve outside agencies. Nothing has to be filed. The company under The ADA is not obligated to put in writing, for example, here are the accommodations we think you should have, and then the employee has a certain amount of time to object or something like that. So in that sense, informal, but it doesn't mean that it's not taken seriously. Of course, some situations are pretty easy to have the quote unquote interactive process. Employee says, I need a larger monitor. Company says, well, how much larger do you need? Employee says, well, I want it to be a 60-inch screen. Employer says, why would it need to be that big? How about we give you 30 inches? And the employee said, okay, yeah, that's fine. I should be able to see what I need there. And it's done and the monitor is provided and everyone goes forward. Technically, that's an interactive process. Of course, in some cases, this will entail the company wanting more information from the employee, some actual documentation from their doctors, for example, as to why they need an accommodation and what the accommodation might need to look like. And I'll talk about that more in a minute. But the interactive process, most importantly, is something that is expected of both the employee and the employer. So if the employer tries to get information from the employee and the employee won't provide it, then that will ultimately reduce the company's obligation to provide the accommodation in some ways. Likewise, however, if the employee asked for an accommodation and the employer just flat out refuses to consider it and engage in any sort of interactive process, that is going to hurt the company in an employment discrimination claim alleging failure to accommodate, even if at the end of the day, the company can make the plausible argument that we probably wouldn't have been able to accommodate this employee. It's going to be a big evidentiary problem that they didn't even try by interacting with the employee. The evaluation step is where the employer is going to consider the circumstances, what accommodations are available, and then whether they create undue hardships. And then the resolution would be advising the employee of the decision that the company has made, either to allow this accommodation or to allow another accommodation or to deny the request altogether, or a finding that the employee doesn't actually need an accommodation to perform the essential functions of the job in the first place. Or it might be, well, here's the accommodation, you just no longer need to perform that function because we don't think it was essential. Any of those types of things could be the resolution. This obviously summarizes the process simply, where there are many cases where the same employee ends up getting an accommodation, the accommodation doesn't seem to work, and then they need an additional accommodation, so the process could repeat itself. Any individual employee, of course, could have multiple disabilities or medical conditions that need to be accommodated in different ways, so this could be going on simultaneously along multiple paths for different medical conditions. Okay, so I'm going to I see there's questions, which I appreciate. Like I said, don't hesitate to put those in. I will come back to those at the end. The goals of the interactive process quickly are to understand the employee's medical limitations, to determine the possible accommodations, to evaluate effectiveness and feasibility of accommodations, choose among available alternatives, and ideally reach agreement with employees on the accommodations, if any, to be implemented. What I really want to highlight here is the fact that the employee is not legally entitled to the exact accommodation that they request if there are alternative accommodations that would also enable the employee to perform the essential functions of their job. The company has the right, as long as they engage in the interactive process and seek the information to determine which accommodations would be effective, to say, we're going to choose this accommodation because we think it would be cheaper or less burdensome on the company, as long as it's still effective and the employee is allowed to perform the job and does not suffer medical consequences as a result, for example, then that's going to be okay. If the employee says, I need a larger monitor, and the company says, well, what we really think you need is a smaller monitor, and in fact that makes it basically impossible for the employee to perform the job, the company's gonna have a hard time saying, well, we provided an alternative accommodation. Well, no, you really didn't. You provided no accommodation, and if anything, you affirmatively discriminated against the person for being visually impaired. Obviously, that's an extreme example, but the flip side of it is the example where an employee says, well, what I'd really like to do is to have a desk that is shorter so that I can reach the desk in a sitting position. And the accommodation that the employer chooses is not to lower the desk, but to somehow raise the chair and the platform or something like that, at which the employees, if the net result is the same and it's clear that the employee can accomplish the same thing with an alternative accommodation, then that is the company's choice. Again, you would ideally like the employee to agree and acknowledge that they accept the accommodation that is being afforded, but they don't have to, and the employer can still go forward and say, this is what we're going to do. Basically, if you don't like it, then your option is to not work here any longer. Of course, most employers won't want to get to that point. They'll want to try to work it out. I did mention obtaining medical information. Unless the medical condition and need for accommodation are obvious, employers can require employees to provide information about their disability. There are relatively few cases where it's so obvious that you couldn't ask for any medical condition. And if it is that obvious, you're probably either accommodating or able to make the analysis without medical information. It's really more the scope of the medical information when you would choose to ask for it. You're not supposed to go beyond the possible need for accommodation. So you can't get a complete medical history on an employee just because they say they have carpal tunnel and need some adjustment to their typing duties. You can ask the employee to sign a release so that the company can get the information directly from the medical providers, like a HIPAA compliant release, or you can ask for the employee to get the information from the doctor and then hand it over to you, in which case the doctor doesn't technically need a release and you don't have to have one to get the information. You do have to maintain the information confidentially once you get it. But of course, on a need-to-know basis within the organization, you can share the information so that the accommodation can be made. We mentioned job descriptions before. When you're asking for information from a doctor, it's usually a good idea to make sure they actually have a job description that's accurate of what the employee is expected to do, and use that in giving feedback on their need for accommodations. And again, kind of like before, where you don't have to get the employee's agreement on the accommodation selected, you also don't have to accept the doctor's opinion, restrictions, or suggestions in all cases. You would normally want to have a good reason for disagreeing with what the doctor says. But if you believe and have some basis for the conclusion that the doctor's recommendation is ridiculous, then you can act on that. You might even want to get second opinion in some cases, and that's possible too, all part of that interactive process, as long as you're being reasonable and not throwing unrealistic obstacles in the way of an employee getting an accommodation. Just a couple more things, and I'm going to answer the questions that are coming in and others. The New York City human rights law, as I mentioned, was amended effective October of last year, specifically regarding the reasonable accommodation issue. So it added this concept of a cooperative dialogue. So again, remember, this is for employees actually working in New York City. So under this law in New York City, the employer and a person entitled to an accommodation, an employee, for example, the human rights law covers additional circumstances. But between employers and employees, they have to engage in good faith in a written or oral dialogue concerning the person's accommodation needs and discuss potential accommodations, including alternatives to a requested accommodation and difficulties that such potential accommodations may pose for the covered entity. So this is essentially the interactive process, but probably a heightened requirement that the employer actually address these factors, which the ADA and New York State human rights law don't specifically identify. More importantly, more tangibly, the human rights law now requires that employers actually provide employees who have requested accommodations with written final determinations identifying any accommodation granted or denied. So this basically means that if you're an employer with employees in New York City and one of those employees asks for an accommodation of a disability, you have to entertain a cooperative dialogue with them, after which you have to provide a summary report, in essence, that says these are the accommodations that were considered and these are the ones that we are providing. This is not something that's ever been required under the ADA or the New York State human rights law. It is now required in New York City, and failing to provide the determination is itself a violation of the New York City human rights law and a form of discrimination. By the way, if you do have employees in New York City, this cooperative dialogue pertains to other forms of accommodation as well, including accommodating employees' religious beliefs, for example, and a couple of others, the pregnancy related, and also there's one for victims of sexual assault. So all those categories get accommodation rights under the New York City human rights law and have these same new requirements. What many employers throughout the state of New York might be concerned about is the possibility of the New York State Legislature deciding that it's a good idea to adopt that determination requirement statewide. If so, if nothing else, it will increase the workload for the human resources people and others within organizations whose job it is to handle these accommodation requests. Frankly, it's an additional burden on employers and a way of providing proof or lack of proof of disability discrimination itself. Two more quick notes. Temporary disabilities under the New York human rights law. There's specific language that requires no more than de minimis accommodation for temporary disabilities. May require reasonable accommodation in the area of modified work schedules, etc. I don't think this really changes anything, both under the ADA and the human rights law. You don't have to focus on this too much. I just wanted to let you know that it's there. It's kind of more the thought that it's a sliding scale, and among the factors that you would have to consider in accommodations are how long the disability is going to last. A disability that's only going to last for 2 weeks is going to probably justify less capital investment in making accommodation than a disability that's going to be long lasting. Installing a ramp so that someone can get from one area of the workplace to another, despite a temporary disability, might not be reasonable, whereas if they're going to have a lasting disability that's going to necessitate a ramp for a long period of time, it might be justified and not considered an undue hardship. Finally, I alluded to this before, the laws do also require employers to accommodate applicants, and in 2 ways, both in consideration of what job they'll be able to do if hired, but also in the application process itself, the hiring process, that is. So if someone needs an accommodation for their job interview, perhaps a sign language translator or some other sort of physical or procedural accommodation, then the employer has to engage in the interactive process and undue hardship analysis, just like an accommodation request within the workplace. It's important to note that employers have to make reasonable accommodations during the hiring process, even if it appears that the employer could not make the necessary accommodations if the employee were hired. So, whereas it might be reasonable to have someone sign to facilitate the job interview, it would be more costly, obviously, as an ongoing matter, to have a sign language interpreter for the employee throughout the course of their employment. Nonetheless, you probably would have to provide that accommodation to the hiring process, even if you later said, we can't have you work here, because being able to speak over the telephone, for example, to other employees or customers, etc., is an essential function of the job. And you normally can't ask applicants whether they will need accommodation in performing the job unless the employer knows the applicant has a disability and reasonably believes an accommodation would be necessary to perform the job functions. You could know either because it's obvious from looking at the individual or because they have already disclosed it. But again, even if you know they have a disability, there would have to be some reasonable basis for wondering whether accommodation would be necessary. The mere fact that someone has a disability doesn't necessarily mean that they would need any accommodation or have any limitation in performing the essential functions of a specific job. Here's my one shameless plug. I do have a book out called New York Management Law, The Practical Guide to Employment Law for Business Owners and Managers. If you're interested, you can find it on Amazon or Barnes & Noble, for example, online in paperback or ebook format. But now I'm happy to answer the questions. A couple have come in. I will, in a couple of minutes, put up the link to the slides. We are close to the end of the hour, but I will stay on and answer these questions as long as they are here. If you need to leave before I post the link to the slides, again, you will get an email that has that information in it as well. Here's my contact information if you do have any follow-up questions. As you're asking questions here, I just remind you that there's no attorney-client privilege in the asking and answering of these questions, even if you are my client, because there are other people around, so don't ask anything too confidential. Follow up and ask me separately. All right, the first question that came in was, how do you limit doctor requests like asking for a standing desk with a doctor's note and other employees follow suit since it's an easy note to get, eventually costing the company thousands of dollars in new equipment, new desk plus paying to remove the old one? Well, I mean, the legal answer, I guess, is that you engage in the interactive process in all cases and not just automatically accept that the doctor says this person needs a standing desk. You have the right to find out what the disability is and make your own judgment as to whether that warrants the accommodation requested of a standing desk. Is there another accommodation that would be allowed? Now, the reality may well be in this day and age, it's not hard, especially under the New York human rights law, for someone to claim that they have a disability. Most people, in my experience, from time to time have some back pain, and most people, probably doctors would agree, shouldn't just be sitting for extended periods of time. So in that sense, I can see where it's easy enough for a doctor to write that note, and what do they care? They're not paying for the desk anyway. There are probably alternative accommodations that could be evaluated. For example, is it sufficient for the employee to be allowed to get up and walk around? Are there sort of centralized workstations that have standing desks that someone could be allowed to float back and forth from? In many cases, the reality is that employees don't actually want to be standing all day. Many would prefer probably the option of going back and forth from a standing desk to a seated desk, and that doesn't necessarily mean that they each get their own adjustable desk. Like I said, you could have sort of a centralized standing platform where people can go and work. It's going to depend on what your workplace is, and again, whether it's an undue hardship and whether the cost is too burdensome will depend on the size of the enterprise and the facility in question, the size of the workforce, etc. There is something called, I think, JAN, the Job Accommodation Network, that you can find. It's sort of a federal government program, although I'm not sure it's actually a branch of the government itself. I can't remember, but you can go to that, and they provide additional resources on accommodations and can assist with some of that analysis. They probably have guidance specifically on standing desks. If you want to follow up, if you can't find that, let me know and I'll help you get in the right direction. Another question: if an employee asks for an accommodation without giving a reason, is the employer allowed to ask for a reason? And is the employer allowed to ask for documentation, or does the employer just have to take it at face value? Basically, you have the right to ask within reason. So certainly employee can't, just to borrow the same example, come forward and say, I want a standing desk, and then trigger an obligation to be accommodated under disability discrimination laws. At that point, I think honestly you could stop and just say no, and then if the employee doesn't say anything else, they don't have a viable failure to accommodate claim. More practically, rather than wait and fight that out legally down the road, you would probably want to say, why are you asking? And then if they say, I just want to have a standing desk, then you probably say, no, sorry, we can't afford that. But if they say, well, I need it for medical reasons, then certainly you can ask what those reasons are. You can require the doctor to tell you what the disability is, what the diagnosis is, what the duration is expected to be. I mean, if someone has back pain because they played in a basketball game last week and it'll probably be better in a few days, then that's not as likely to justify a standing desk as someone who has had back surgery in the past or something like that. Again, just to sort of belabor that example. And yes, you can ask for documentation, except in the case where the need for accommodation is, blatantly obvious. Thanks. Yeah, someone has posted the Jobs Accommodation Network, JAN, is the resource that I was referring to. You should be able to find that online. I mean, it's basically a neutral party. I mean, certainly they focus on helping employers figure out accommodations, but their goal is to have resources and information available. They don't necessarily have an agenda, and they're not going to try to blow you into the EEOC. Here's a question: what about someone requesting an accommodation that is not visible but is refusing to go to a doctor and provide medical backup, like for a seizure disorder? Yeah, and I tried to emphasize this, but I think this is where it comes in a tangible way. The employee has the obligation as well to engage in an interactive process, and that interactive process includes providing the information that the employer needs to evaluate accommodations. If they refuse to provide information, assuming the request is reasonable in the first place, then ultimately that can result in the denial of the accommodation, and then potentially the denial of the accommodation could ultimately result in the loss of employment, because without the accommodation, they won't be able to perform the essential functions of the job. So yeah, it's pretty clear under the both the Americans with Disabilities Act and the Human Rights Law that just saying that you need an accommodation is not enough to entitle you to one. That being said, someone whose leg is in a cast who says that they need to be allowed to use crutches to get around in the workplace, where maybe for other purposes you prefer people not to have walking devices or something like that, it might then be less reasonable to ask them for medical proof that they actually have a physical impairment with their leg. That being said, if you had some reason to believe they were, just wearing a cast and don't actually have a medical condition, then you could probably even question that. But there are cases out there emphasizing that the interactive process is a two-way street. So good questions. Like I said, I get questions like this all the time, so I'm not surprised that we have good questions. If there are any more questions, please get them in. But now I'm going to go ahead and put up that link to the slides. So you should be able to click and get the slides and download them that way. Like I said, if it's easier for you, probably tomorrow an email will go out and you will have access to the slides that way, as well as a link to the recording of this webinar if there's anything you want to watch again, or if you have any colleagues that you want to share it with. So hopefully I've answered the questions sufficiently that were asked. I don't see any new questions yet, but I will wait another minute or so to see if there are any more questions forthcoming. Otherwise, I will wrap this up, but I do thank all of you for participating and hope you found this helpful. I know many of you have been dealing with accommodation issues for a while, and I just thought it'd be helpful to see and hear some of the legal points and just some of the reminders at the margins as to what the obligations of the various parties are, and some of the pitfalls. So hopefully this has accomplished that. Just wait maybe 15 or 20 more seconds to see if anyone has a question. If you're half through a question and want to hit return so it comes up, I will wait to see the rest. All right, well, I don't see any more questions coming in, but I appreciate the ones that were asked. Again, I appreciate your time for participating today. Been my pleasure to present today's webinar, and we will continue to do these periodically going forward, and I hope to see you back in the next one. Thanks.